Okay. Well, hello and welcome to panel number 20 of this SIEL conference. Good morning from Brussels to all of our participants from Europe and around the globe. My name is David O'Sullivan. I'm a senior counselor at the law firm of Steptoe and Johnson, and I'll be the moderator of this panel. Our theme is the economic relationship between the EU and the UK, otherwise known in popular parlance as Brexit. It is just over 5 years since the British electorate stunned us all by voting by a margin of 52 to 48% to leave the European Union. The intervening years have been filled with drama, with major political upheavals in the UK and challenging negotiations between the UK and the EU on both the terms of the withdrawal and the nature of the future trading relationship. A withdrawal agreement, WA, was concluded in December 2019, which meant that the UK formally left the EU on 31 January 2020. This agreement basically resolved the most immediate contentious issues around the budget, the rights of citizens, and the vexed question of Northern Ireland through the Northern Ireland Protocol. It created a transition phase of 11 months until the end of 2020, during which the status quo ante prevailed. Further negotiations during this period on the future relationship yielded a new trade agreement known as the Trade and Cooperation Agreement, TCA. The TCA eliminated tariffs in future EU-UK trade, resolved at least partially vexed issues such as the level playing field provisions and fisheries, and foresaw the creation of a complex structure of committees to manage the relationship. Therefore, at midnight Central European Time 2020, the UK severed all remaining ties with the EU. The WA and the TCA constitute the new basis of the EU-UK relationship. Many issues, of course, remain unresolved, notably the question of trade and services. We're going to explore some of the implications of this over the next hour or so. We have an excellent panel. None of them will address the most topically contentious issue of the Northern Ireland Protocol. As an Irishman, I'm happy to answer questions on that in an unbiased way later if needed. First up will be Johanna Jacobsson to discuss the issue of trade in professional services. Johanna is assistant professor at IE Law School in Madrid, Spain. She holds a PhD from the European University Institute in Florence and LLB, LLM and BA degrees from the University of Helsinki, Finland. Prior to starting at IE Law School in January 2017, she was a law clerk at the Court of Justice of the European Union, a researcher at the Finnish Institute of International Affairs, and a practitioner in a law firm. Next, we will have Vasyl Chornyi to look at the very complex but vital issue of rules of origin. Vasyl is an international trade and customs lawyer currently employed as a senior consultant in the global trade advisory practice of Deloitte, Netherlands. Vasyl holds a law degree from Kiev National Taras Shevchenko University in Ukraine, an LLM in International Comparative Law with distinction from the University of Nottingham, and an LLM in Comparative European and International Laws from the European University Institute in Italy. Emily Lydgate will then share her thoughts on the implications of the new EU-UK relationship for the all-important question of climate change. Emily is a senior lecturer in law at the University of Sussex and deputy director of the UK Trade Policy Observatory. She has consulted at the UN Environment's Economics and Trade Branch, where she acted as a WTO liaison, and is an instructor on the UK Foreign and Commonwealth Office's Diplomatic Academy. She's also a specialist advisor to the EFRA Committee of the UK House of Commons. Finally, David Collins will look at the impact of the TCA on foreign investment. David is a professor of international law at City University of London. He's co-editor-in-chief of the journal International Trade Law and Regulation and series editor for Routledge's Insights on International Economic Law. David was appointed to the roster of trade remedy panelists under NAFTA, now known as the USMCA, by the Government of Canada. Before we start, just one or two housekeeping points. I need to alert everyone to the fact that the session is being recorded. Please be aware. And we have asked their panelists to keep their remarks to a maximum of 8 minutes so as to allow for questions and dialogue at the end. Questions can be asked via the public chat. I've never used this particular platform before, but I'll do my best to keep an eye on it. I see that the chat is already active, and I see that we had one person who has just solved a technical problem, so that the system seems to be working. Okay, that's all from me for now, and now we will begin our presentation. So firstly, Johanna, the floor is yours.
Thank you very much for that introduction, David, and good morning to everyone. It's great to be on this panel with you this morning. We have very different topics among the 4 panelists, but I'm sure we will find some common ground in all of them. So I will be speaking about services, and even more specifically about professional services, which is a key services sector for the UK economy, as I think we are all aware of. The TCA is not a great negotiation outcome for the services sector in general, and even less so for the professional services sector. And actually, the poor level of the liberalisation of services in the TCA is likely to hit the UK's professional services sector quite hard. And I would say that particularly the smaller providers who do not have the means to follow the new rules, let alone even understand what the new rules actually mean in practice. But it's also important to realize that many of the effects of moving from the single market to a more traditional trade agreement framework are not yet visible due to the COVID restrictions. And especially travel restrictions relating to professional services will be more visible and evident once the professionals start traveling again and we all get out of this pandemic. My presentation is divided in 3 parts. I will firstly shortly introduce the current state of play of professional service suppliers under the TCA. Secondly, I will address some ideas that I'm currently developing to think of better ways to liberalize professional services. And then thirdly and lastly, I will address the complex issue of mutual recognition of professional qualifications. Okay, so to start off, first about professional services in general in TCA context. Professional services are a service sector that includes relatively high-skilled people, such as lawyers, doctors, accountants, and architects. If you look at the WTO services sectoral classification list, you will see that professional services are part of the first category, the big category of business services. Now, the UK enjoys quite a significant trade surplus when it comes to international trading services. Much of this surplus comes from financial services, but actually a big role is also played by professional services, such as legal and management consulting services, as well as in information and communication services. Of course, many of these professionals support the huge financial services sector of the UK. Now, considering the importance of the services sector to the UK economy, it's really quite astonishing how modest the TCA is in this regard. At the heart of the TCA is really a classic, but not a very ambitious free trade agreement. There is, of course, the tariff and quota-free trade in goods, but there is very little mutual recognition on services and very modest commitments on services in general. Whereas in the single market, the UK professionals were able to move freely and provide those services in the entire EU, of course, subject to the treaty exceptions, of course. In the TCA, the access of UK professionals to the EU market is hindered by new country-specific barriers, as well as the lack of recognition of professional qualifications. To provide paid services in the European Union, UK professionals now, they generally need a visa or a work permit, and this is a separate procedure for each EU member state. As well as complying, they have to comply with each EU member state's own national rules regarding qualifications, allowed practice areas, the types of legal entities that they are allowed to engage in, and many other requirements. The TCA provides for very little coherence in this sense. Therefore, UK professionals now selling services to the EU have to check the applicable regime in each single member state, whether it's about immigration rules, professional rules, or recognition of qualifications. I'm now moving to the second part of the presentation, and here I want to really very briefly discuss what could be done to provide for a deeper liberalization of professional services. I believe that Brexit would actually have provided a great test environment for more innovative services rules, considering that the place of departure was EU membership. So this was really a unique situation where the parties could have done some more innovative thinking in this regard. And just because UK was an EU member before Brexit, there was supposedly quite a deep trust in each other's rules and regulators on both sides. This is the presumption in the European Union, at least. And this type of trust, together with the adequate level playing field rules of the European Union, has enabled the deep integration of the European Union, also in the area of services. So I'm asking if we could somehow replicate this environment, or the starting point at least, in an international trade agreement. The TCA would have been a good test case indeed. But how would the parties have been able to create conditions in which they could still trust each other as to allow for liberal access rights to each other's professional service suppliers, even when moving from a single market to a trade agreement framework? So I'm thinking that in addition to the general level playing field commitments that we already have in the TCA, and I believe that at least David Collins will address those in his intervention, I believe that in addition to those, we could have had some more specific sector rules on professional services. And these could include, for example, certain non-regression clauses, for example, on educational levels, professional standards, ethical codes, and liability rules, for example, just to name a few. There could potentially be many more areas. And these non-regression clauses would mean that the parties could not weaken any of these standards or distance too much from each other's rules, or they would then risk losing access to each other's markets. These types of disciplines may, of course, be hard to achieve, considering that the rules for many regulated professions are set by professional bodies. But in the end, it would also be in the interest of these professional bodies not to lower their standards in order to keep their access open to foreign markets. And actually, if we look at the UK side, the UK is actually doing something similar to this approach. The UK, to my knowledge, is now retaining a general recognition system where UK regulators are actually required to recognize the EEA and Swiss qualifications, so European Economic Area and Swiss qualifications, which are of an equivalent standard to the UK qualifications in scope, level, and content. And something like this could have been included in the TCA too. And maybe this should be thought about for future agreements of the EU, maybe with other countries as well. So now I move to the third part of the presentation, which is specifically about the recognition of professional qualifications, and even more specifically about the related competencies on the EU side. So the TCA rules on this issue of qualifications and their recognition, they are very limited, and they are very similar to EU's other recent trade agreements. They basically only ask for the relevant professional bodies to come up with recommendations for recognition, and it's up TCA part council to decide them or not. However, the adoption process does not include the member state, but is the EU member states, but is done in the Partnership Council, where you have the UK and EU alone as chairs. At the same time, however, the member states keep having their own national rules on the recognition of foreign qualifications. Moreover, these national rules are actually specifically allowed for in the applicable secondary legislation of the EU. And moreover, several member states have bilateral agreements of professional recognition with third countries. Now, in the Singapore opinion of 2015, the EU's Court of Justice accepted that the recognition of professional qualifications is in the exclusive competence of the Union. The court didn't say much on this, but the Advocate General Jacobsson recognized that these are indeed in the exclusive competence, but on the other hand, she seemed to at least tie this issue to the modest mechanism that the EU has so far used, at least in the Singapore Agreement, in CETA, and now with the UK. So where you basically don't have a full competence to come up with recognition schemes, but there's this complex recommendation adoption system, at least for the moment. So the question is whether more far-going recognition rules would still be covered by the exclusive competence, and this is, in my view, still left open by the EU court. And finally, I would like to highlight that this issue becomes even more complex when we look at the text of the TCA, because you actually have a footnote in Article 158, which is about this professional recognition mechanism, that says that the parties may conclude one or more agreements on the recognition of professional qualifications outside the provisions of that article. Now, various operators, particularly professional bodies in UK, have interpreted this provision as saying that bilateral agreements would be possible between the UK and the member states. However, in my view, this would really bypass the wording of the TCA, which refers to the parties as the UK and the EU. This is an EU-only agreement. So all in all, it remains a bit unclear, and not really a bit, it remains very much unclear to what extent the member states would be able to conclude bilateral agreements with the UK, and how would this then play out with the other bilateral agreements that the member states have with other countries. So we may end up with a web of arrangements, the legality of which then is finally up to litigation in EU courts. So to conclude with the final words, the professional service suppliers were left with very little in the TCA, especially on the UK side. They have to face complex country-specific rules in the European Union, while they would not seem able to secure bilateral recognition deals with the individual European Union member states. There's still very much to say on this topic, but I'm sure I'm out of my time, so I will stop here. Thank you. You're muted, David.
My apologies. I was going to say that it is a very interesting subject, and I'm sure we will come back to it in the questions. But thank you for sticking to the time. That was very impressive. Vasyl, please, on the rules of origin.
Thank you, David. Good morning, everyone. Just before presenting my paper, I would really like to mention that I feel privileged to share the digital floor with such a distinguished panel, and I very much look forward to the two other papers and to the subsequent discussion. My paper deals with the technical subject, rules of origin. I do appreciate that might be not something that many of you deal on a daily basis. So I will not bore you with the detail and just focus on the bigger picture. And I'll just talk about the research question I tackled and about my main findings. I do hope, however, that there will be some questions afterwards, so we can zoom in on some particulars. So I encourage you to ask about rules of origin. And if you do have a burning question about rules of origin, now would be a time to raise it. I can't guarantee all the answers, but I do promise to give it a good try. Now, when thinking about my talking points, I've actually realized something important that I would like to share at the beginning. Perhaps it doesn't come very clearly in the paper itself, but that's my background assumption. So when I talk about EU-UK Trade and Cooperation Agreement, I use WTO as a benchmark. So I use the MFN terms of trade as a benchmark. And I ask the question, so what's the value added? In other words, does the EU-UK TCA expand and help trade between EU and UK, or does it actually result in more trade barriers for the EU and UK in their trade with the rest of the world? So this is the analytical lenses of my analysis. Now, in terms of the research itself, just a few words on the methodology. Obviously, when we talk about such a technical subject as rules of origin with so much detail, it's much easier to do empirical research and to comprehensively analyze the effect of those rules. One needs to look at them empirically. Empirical research was, however, outside of the scope of my paper, so I focused more on the qualitative analysis, and I took some of the political economy assumptions as a starting point, mainly that when governments conclude trade agreements, they listen to industries. So in other words, governments are susceptible to the voices from well-organized industry groups, and they will try to rebalance the cost of trade agreements. So that's also the methodological assumption here. In terms of the analysis itself, that went into two steps. The first step, I look at the rules of origin that the EU includes in its trade agreements with other countries, and I put next to those rules the rules of origin that the EU negotiated with the UK, and I compared the two. The result of that comparison was that the rules of origin included in the EU-UK trade agreement are not that different. In fact, conceptually, at the level of main approaches, they're quite similar. The consequence of that conclusion is that, it's twofold. On the one hand, yes, those rules resemble the rules of origin that the EU negotiated in trade agreements, especially with advanced economy partners, such as Canada, Japan, South Korea. And that means they contain some of the simplifications and improvements, such as the use of self-certification as proof of origin, and not including the option of government-issued certificates of origin, which makes it easier for businesses to comply with. The other side of rules of origin in the EU-UK trade agreement being very similar to other EU preferential rules of origin is that all the criticisms that generally have been levied against those rules could also be applied by extension to the EU-UK trade agreement. So the main criticism here, and that has been already documented in the growing amount of economic literature, is the propensity of those rules to grant protection to domestic industries. And that's most visible at the level of trade in inputs. So that rules of origin are kind of local content requirements that make traders, the force traders, to use components from, let's say in this case, EU and the UK, instead of using components from the rest of the world. So at the general level, that's the main problem. Now, that was sort of the first exercise in my paper. Then as the second exercise, as the second step, I also looked at some of the particular features in the EU-UK trade agreement when it comes to rules of origin that also, made them look suspect from the perspective of protectionism or suppressing trade. And here I just pick several. Well, first of all, if we look at some of the, let's say, I'll call it small print, but there are transitional rules for electric accumulators and electrified vehicles. The essence of those rules is that until 2027, you have more flexible rules, meaning that international supply chains could source components from the rest of the world relatively easy. Now, after 2027, it becomes much more difficult. It's a very stringent rule of origin, which basically means, I guess, good thing for investment. Companies are going to invest in the UK and the EU to make cars here. Well, you can say, well, good for investment, good for the economy. Well, the problem is that it's a market distortive decision-making. That means that investment that could have been made more efficiently elsewhere is now going to be made in the EU or the UK. The other, I would say, notable feature in the EU-UK trade agreement when it comes to rules of origin is the use of origin quotas. Well, we know about quotas when we talk about tariff rate quotas. Well, here we have origin quotas. Well, never mind the wording. If you think of how it's going to work just like a tariff rate quota, because the cost of complying with the most stringent rule of origin would be just like paying the tariff at the border. Now, last but not least, lack of diagonal accumulation. Well, what is diagonal accumulation? It's a technique that helps international supply chains to accumulate the benefits of several trade agreements at various stages of production. So it works if you have more than 2 countries, all of them have trade agreements among them, and you use components from one country and then export finished products to another country. So with accumulation, you can import components duty-free and then export final product duty-free. Without accumulation, very difficult. Now, EU-UK trade agreement, what contains no provision on diagonal accumulation. And that makes it very difficult because international supply chains would just suffer fragmentation because of that. I think I'm going to stop here. My general conclusion is that, yes, EU-UK, the rules of origin in the EU-UK trade agreement are very similar to other preferential rules of origin in the EU, but that also means that they unfortunately continue the idea that we trade on preferential terms on bilateral basis at the expense of the rest of the world. So we heard multilateralism and we go towards the path of bilateralism. Thank you.
Thank you. Thank you very much. I know that people do think rules of origin are rather esoteric as a subject, but actually as a former trade negotiator, I can tell you they're hugely important. And they're one of the things which really determines, to a certain extent, the economic value you can get out of free trade agreements in a very serious way. So thank you for looking at that, and I'm sure we'll come back to it. Next, we have Emily to talk about the impact on climate change.
Thanks very much. And Johanna and Vasyl, I'm going to try to draw some connections with your papers a bit later on. But for those of you who are at the sort of carbon border adjustment debate yesterday, what I'll really be doing is sort of drawing a line between that and Brexit. The starting point for this journey is Nordhaus's proposal of climate clubs, which, for those of you not familiar, is a kind of economist proposal that, well, we don't have a high international carbon price, but countries with ambitious climate targets can band together against the rest of the world. They can impose import duties on them, but not on each other. And if enough countries do this, it increases the incentives to join. So this is basically, a trade policy proposal. There's a lot of questions you could ask from this starting point, but the question that I'm looking at today is, how do you join a climate club? And I'd like to argue that, in order to sort of bridge the gap between a unilateral trade restrictive measure, like a carbon border adjustment, notably, and a plurilateral or minilateral or whatever you want to call it, climate club, membership probably has to be on the basis of relatively high-level objectives. So you might describe this as sort of an equivalence model rather than a harmonization model. And that the TCA provides a kind of a decent template for this. And even if you disagree with that, it's a really interesting prompt to start thinking, to think through whether and how we can use FTAs to join climate clubs and what some of the issues that arise are. I guess a preliminary question is, isn't this a bit premature? And I think that's a very live question. We have the EU committing to introducing carbon border adjustment by the end of 2022, which is a kind of, unilateral climate club of 27. That's the anachronistic nature of the EU. We have others like Canada, the UK, and possibly even the US contemplating also introducing some sort of border carbon tax. So there's a potential for a kind of de facto transatlantic alliance or club there. So the question is, how will countries sort of agree to waive fees against each other on a country basis? So on the one hand, they could say, hey, if you want exemption from our carbon pricing on a sort of country level, you have to be part of our carbon pricing. And that's the proposal that the Commission has put forth in its leaked proposal, which is, in order to achieve a blanket exemption, we have to link ETS schemes. So that's a kind of a harmonization model. This is obviously quite a high bar. If we look at the sort of anyone who follows the Article 6 negotiations of Paris Agreement, or we hear these rumors of sort of Switzerland taking 7 years to join. So probably not compatible with the speed at which we'd like to see climate clubs progress. On the other hand, we could be extremely laissez-faire and say, hey, you know what, we both share a net zero emissions by 2050 target. So let's assume it will be equivalently expensive for your domestic industry, no matter how you get there. But this is problematic as well. Let's be honest, there's no guarantee anyone will meet their net zero targets. And this very clearly runs into MFN problems, though I'd say, those are hard to avoid anyway with carbon border adjustment. But in any case, this points to the need for a sort of a Goldilocks model, something in the middle. This might be a more sort of granular sectoral agreement, which the Commission has also sort of intriguingly referred to, where we agree pricing is equivalent for, say, steel or perhaps more broadly across priced sectors, but we maintain separate domestic carbon pricing and regulation. So I would argue that sort of equivalence model is probably the most feasible, and here enters the TCA. So Johanna and Vasyl both, I think, what came through both of their presentations is that the TCA wasn't really, in some senses, able to move beyond existing FTA models or problems. There were some sort of failures of innovation. And I think that the climate provisions of the TCA actually, there's a different narrative with them. And I would even argue that the very sort of bizarre and unique circumstances that gave rise to the TCA actually give it sort of more demonstration value, because they resulted in a genuinely innovative approach. And also the UK in particular had a desire to avoid harmonization, which means this sort of speaks to how countries with differing climate regulation could establish equivalence in their level of climate protection. So what does the TCA do? In brief, the UK and EU commit to a net zero by 2050 shared ambition. They agree on interim quantitative greenhouse gas emission reduction targets with reference to domestic law. This is subject to a non-regression requirement tied to sanctions. And both sides commit to an effective system of carbon pricing, also linked to sort of binding dispute settlement, and give serious consideration to pursuing linked ETS schemes, but there's no outcome duty there. So there's a lot of firsts here. As far as I know, this is the first time that a net zero target or enforceable emissions reduction targets have appeared in an FTA. It puts sort of dialogue on carbon pricing effectiveness and ETS linking within the institutional framework of an FTA and all of its many implementing committees that David referred to. So, and then finally, there's a so-called rebalancing mechanism. I think David Collins is going to talk quite a bit about this, so I won't sort of steal his thunder, but basically it's about a failure to keep pace. If one side raises its ambition and this results in material impacts on trade and investment, there's a fast track dispute settlement mechanism. So why is this innovative? Well, it's kind of a hybrid between a deep integration association agreement model of harmonization and a shallow FTA, which basically uses existing domestic environmental standards as a non-regression baseline. So here we have something a bit unique. There's specific shared targets underpinned by strong enforcement mechanisms. So I think we could describe this as a benchmarking approach, or maybe even a enforced dynamic benchmarking approach. So this is, I think, a useful and interesting model. I recognize there would be lots of problems with using this as the basis for waiving carbon border adjustment fees. So for example, how do you, if we extend this more widely, how do we sort of maintain equivalent prices or determine that? But it still seems to me worth considering seriously, and because it's preferable to the counterfactual, which is climate allies trying to join up their carbon pricing and in the meantime imposing lots of new technical barriers to trade on each other, getting angry about them imposing lots of new tariffs on each other, which is sort of the opposite of a climate club. Maybe I'm being too imaginative here with my counterfactual, but maybe not. But I think at the core, and what I'm really getting at here is that carbon border adjustment mechanism is a high-risk proposal because of this potential that it will unleash more tariff retaliation. And the more that climate clubs can be based on these relatively high-level objectives, the more likely we are to end up with a plurilateral climate club. So I will stop there.
Thank you very much. That's a very, very interesting sector. You were talking about the CBAM, and that probably was a SIEL CBAM section. I didn't do it. I was on another discussion panel about that day before yesterday. Yes, we're waiting to see what the Commission actually proposes next week. We've seen the leaked document. It's going to provoke a very interesting debate. I'm certain that it's interesting. I also agree with you that the climate chapter was one of the few areas in the TCA where the level of ambition was somewhat higher and a bit more innovative. So let's see what the scope is for taking that forward. Now we turn to the issue of investment, and the presentation is from David, please.
Thanks very much. I'm delighted to be here, everyone. I should say I've been submitting abstracts to the SIEL conference for the better part of 10 years, and this is the first time I've been accepted, so I'm very happy to be here. I'm going to talk briefly about the investment provisions of the TCA. And my suggestion, and I think it's very much in line with what some of the other speakers have said, is that the TCA is fairly thin here. It's not a very ambitious agreement in that sense. Just to get a sense of the importance of foreign direct investment between the United Kingdom and the EU, at least from the UK perspective, almost 80% of the inward FDI into the UK comes from the EU, at least it did in 2019, and it was about 30 billion pounds. And about 40% of all outward foreign direct investment from the UK goes to the EU. Now, FDI flows between the two countries have been falling over the last few years since the referendum, but to be fair, they've been up and down as FDI flows tend to do for long periods. So overall, there's perhaps some concern that UK-EU FDI isn't as robust as it once was, and that steps should be taken to preserve that important economic element. We talk about trade so much, and sometimes I think we forget about the investment element. Now, the capacity to facilitate investment between the parties was one of the agreement's objectives, and you can see that in the preamble of the TCA. And it seems as though the TCA was more designed to liberalize new investments rather than protect existing ones. Now, I understand you've got issues of mixity, member state competence. You have issues of the very short time frame that we had to get the TCA for political reasons. Now, putting those aside as perhaps explanations why certain things are not there, let's look at what I would suggest maybe is missing from the TCA in terms of what you would often see in a conventional free trade agreement. I should add, and I would really like to get comments from others on this because I'm not sure if I'm right or not, there are a number of UK EU member state BITs, and the termination agreement of 2020, as we know, terminated all the intra-EU BITs, but I believe the UK member state BITs are still intact. So there's a few with Romania, Estonia, Latvia, and so on. So I think those are still applicable to investments between those countries. So investment is dealt with in the services chapter of the TCA in a section entitled Investment Liberalization. There's a market access provision which prohibits quantifiable limits on foreign enterprises in language that looks a lot like the GATS. And it talks about you can't have certain restrictions based on certain type of venture. There is no guarantee against expropriation without compensation. There's no fair and equitable treatment. There's no full protection security. There's no investor-state dispute settlement. Now, that may reflect the parties' comfort with each other, their sense that they're happy with each other's legal systems. Again, it may be negotiation difficulties. There is a most favored nation provision, which expressly does not cover ISDS found in other treaties. And there is a prohibition on performance requirements, which goes beyond what you would find in the TRIMS agreement, the WTO TRIMS agreement. For example, by prohibiting mandatory technology transfer. The national treatment obligation is there, and it extends to the pre-establishment stage. However, there's many reservations. There's many broad lists of reservations in areas where discrimination based on nationality is permitted. Now that brings me to the level playing field. I just want to make a few comments about that, because the the level playing field obligations expressly cover foreign investment. So the non-regression clause, which requires parties not to lower their standards in things like labor and the environment, specifically refers to a manner affecting investment between the parties. So you can't weaken your standards to make yourself more attractive to investors. And this can be responded to through retaliation in the form of tariffs and so on. So this is effectively a new kind of trade remedy. Now, my opinion, and I think that my sense is that most commentators agree with this, is that the rebalancing mechanism is framed in incredibly narrow language. It's a very high standard materiality. The case law on non-regression from other free trade agreements suggests that these are it's a hard case to make, that standards have been lowered for these objectives. There's a strictly necessary standard for measures taken in response to the deviations, in this case, tariffs, and an assessment of the impact of the breach of the level playing field obligations must be based on reliable evidence and not merely conjecture or remote possibility. So this is a high standard of proof, and I would suggest that it's particularly high in the context of foreign investment, because think about what the counterfactual is to prove that the other side has lowered its standards to attract investment. You'd have to show that a company located in the UK that would have located in the EU or left the EU to the UK or vice versa. You've got FDI flows going up and down every year. I think this would be really, really hard to make that case for foreign investment. It might be easier for trade, but for investment, I just can't see how these provisions have much significance. And just as perhaps some closing comments, I see I've got about a minute left. Some of the emerging areas that might engage these obligations, and I think at least in Britain we often see this as, it's often said this is a way that the EU is controlling Britain's competitiveness, but it could easily go the other way. I'm wondering about the UK's new state aid regime and how that might be seen as perhaps giving advantages to foreign investors. The UK has a new Foreign Investment Act. Now this tends to put restrictions on foreign investment, but I can imagine that might in some way be viewed as facilitating investment or departure from regulatory standards. And then on the EU's perspective, I can't help but think about Ireland and its low tax regime. And if there is a standardization of corporation tax, would the Ireland's maintaining a low standard be somehow seen as a way of inducing for foreign investment that could also be perceived as a departure from the LPF? Okay, I'll stop there. Thanks very much.
Thank you very much, and thank you to all of you for sticking so closely to your time limits. Much appreciated. Well, there's a lot to digest there. We already have a couple of questions, so I'm going to, if I can find them again now. We have a couple of questions from the audience, so I'm going to pass these on to start the discussion off. Johanna, Marcia Harpaz is asking you, saying, aren't the GATS schedules the new point of departure for both sides?
Thank you for the question, Marcia. I'm wondering if I understand the question correctly. New point of departure, that is probably what they are not. So first of all, here, we don't have the GATS commitments as a point of departure because we have the TCA commitments as a point of departure. So the TCA is a preferential trade agreement, it's a free trade agreement that the UK and the EU have agreed in order to go further than the WTO, of which GATS is a part. Now, of course, the GATS asks for parties to go quite far in order to have a legal exception to the GATS rules. And this we know from experience that generally services agreements do not go very far. I wrote my PhD thesis on that, and I can tell you that the GATS rules are not respected because the services agreements seem to be very shallow. And I would argue that the TCA is also very shallow and actually does not comply with the GATS exception for a preferential trade agreement. Okay, but that put aside, so if we look at the TCA schedules of commitments for services, yes, there is a lot of similarities still, unfortunately, with the GATS, meaning that we haven't come that far from the original WTO commitments of the EU. But it does look quite different. So now the EU's latest services agreements, they follow this kind of a mixed scheduling where you have negatively listed commitments, meaning that you have schedules of reservations laid out separately for existing measures and then future measures. So this is the new model. So it looks quite different to the GATS commitments that EU's earlier or the early PTAs. Now there is improvement there, and you would also see that there is some more common EU commitments. But in general, if you look at the EU's commitments, you will still see that the big chunk of the reservations are still member state specific. And this is really the funny thing that people don't often talk about, and which I think is quite weird, that we have the exclusive competence for services, but in practice, it's the member states that put forward their own national limitations. So in this sense, the EU is really like a federal state. EU schedules look like US schedules or Canadian schedules, where you have the state-specific limitations. So the common commercial policy for the European Union in the area of services is still far from complete. It really reflects the lack of completeness of the EU's internal services market. So this really shows towards third country service suppliers. This really means that they have to go through the EU services schedules and look at the specific limitations, reservations in each specific member states. There is some more coherence, especially because we have some new harmonizing EU legislation, for example, for intra-company, inter-corporate transferees or contractual service suppliers. There's some more coherence in the EU's latest schedules as compared with the original GATS commitments, but this diversity across the member states still remains. I hope that answered at least partly your question.
No, and your development on the last point is, of course, very, very valid, that we're still in a sort of hybrid situation on services, which makes international negotiations very difficult. And I know that for the TISA negotiations in Geneva, the Americans were particularly angry about the number of member state reservations we were keeping, which were quantitatively very, very, very high. But I think the best efforts of the Commission to get the member states to reduce them was unsuccessful. Vasyl, you may have thought that rules of origin were esoteric, but we've got two questions for you. One also from Marcia, asking you about the accumulation for electric vehicles. You said might change in the future, and how would that affect the could that mean that will make electric vehicles manufactured in the EU UK more expensive in the future? And one from Annika Velling, which is again about the accumulation rules. What would happen if the UK negotiate FTAs with considering EU material as originating, even though the EU would not be a party to those FTAs? So perhaps you might like to take those two questions, Vasyl.
Thank you, David, and thank you for the participants for asking these questions. Very interesting questions, also very complex. So I'll start with the first one on the transitional rules for electrified vehicles. So that we are talking about hybrid vehicles, but also for fully electric vehicles, and also for the electric batteries, for accumulators for those vehicles. So currently there are more relaxed rules that would apply until 2027, and then more stringent rules would apply afterwards. There are no other products that would be subject to such transitional rules, but there are products subject to origin quotas, and those are certain aluminium products and certain preserved types of fish, such as tuna. For the rest, it's just the regular rules, well, the regular product-specific rules that would apply. But well, if we are talking about electric cars, where the sourcing components from the EU and the UK would make them more expensive, I believe yes. It's, if you source a component from China or from another Asian country, it's likely to be cheaper. If you source it from the EU or the UK, it's likely going to be more expensive. So yes, in the end, the consumer will pay the surplus of that situation, of the fee, basically. So that's the first question. The second question on diagonal accumulation. Yes, indeed, it's a curious development where when the UK basically copy-pastes a trade agreement that the UK applied as part of the EU into now its own agreements with other countries. They also transpose some of the rules on diagonal accumulation. We've already seen that. Indeed, I think Mexico was mentioned, and perhaps Norway and some other agreements. From a policy perspective, it makes me wonder even more why diagonal accumulation was not included in the EU-UK TCA, or at least a possible reference to the PAN Convention. Now, I wasn't close to negotiations, and there is also the issue of transparency. When we don't know what's happening, we don't know what kinds of rules we're going to get. It's, Christmas time. There you go. You have a EU-UK TCA agreement. You have the full table, based on HS codes. Yeah, go and figure out what kind of rule will apply to your product. Well, I think that's the reality, and perhaps David O'Sullivan might have a better insight on this. From the practical perspective, when the UK does this kind of unilateral diagonal accumulation, I believe you run into trouble with proof of origin, because you would need to provide a so-called suppliers declaration from the EU that something comes from the EU, but in fact there is no legislative basis in the EU for the company that provides input to certify that that input comes from the EU. So it kind of makes it still a little bit hard to apply that in practice. But I'm curious if someone has experience on that. I'm curious how you did it. Thank you.
Thank you, Vasyl. Well, I mean, yes, the whole TCA was negotiated in very, very short time. And it also, I mean, I should have said this at the beginning perhaps, but I mean, it has the whole exercise has the very unusual feature that it was not negotiating convergence, it was managing divergence, because you started from perfect convergence, UK membership of the EU, and then you were basically designing something which was less below that as a standard, and then you had to, so it was I compared it once to the equivalent of a slow bicycle race, you're not trying to go see who wins by going the fastest, who goes the slowest almost. So it was a very strange negotiation. Emily, I'd like to come back to you, if I may, on the climate change, because this is going to be very topical with the Commission proposals next week, particularly for people like us on the CBAM. Do you have any sense of what the thinking is in the UK about how they intend to manage their ETS, and whether they would want to link it, or whether, again, as part of their desire to demonstrate that they're not linked to the EU, they will try to keep it completely separate?
I mean, it's just another one of these interesting things, with Brexit, where we have sort of de facto alignment already, but de jure, neither. The UK is very nervous about alignment. So, things like, for example, the UK has a carbon floor. The EU's never been that thrilled about that, but the UK was an EU member, so we let it fly. Now that might be a negotiating issue where the EU actually has a higher demand of the UK in terms of carbon floor. I mean, this is just speculation on my part, but that the longer we wait, the more divergence will happen naturally, because the EU has its commission its plans with the ETS, which are in development. The UK might go in a different direction. So, I mean, I would hope that we could join them because they are virtually the same at the moment. But I think it's, you know, it's a bit like parallel to the Northern Ireland Protocol, where there's just a certain allergy to to admitting that we're doing the same thing. And then in terms of you know, another question is obviously what are the UK's thoughts about carbon border adjustment, because it's going to be one of the most exposed countries to the Commission's proposal. So, and again, I think the UK is very conscious of its sort of COP presidency. It sees the CBAM as a divisive proposal. So I wouldn't expect to see much action from the UK until after the COP. I think they're in a sort of evidence gathering phase right now. So they have a big consultation with industry. Tell us about leakage. So they're trying to find an evidence base for leakage, which is, you know, not easy to do, but we'll see.
Watch this space. David, on the investment, two questions. I mean, during the Brexit debate, one of the arguments was, of course, that the UK would become less attractive as a location for investment because they would lose the automatic access to the EU market. And of course, there was all the speculation, particularly about the Japanese investment. Nissan famously. Now Nissan have announced that they're going to build an even bigger factory. What's your overall assessment of the impact on investment in the UK, and linking that also to the point you made about the new state aid regime, which the British are just putting in place?
Thanks, David. I guess my overall sense is the general effect will probably be a negative one, but I don't think it will be as pronounced as perhaps some of the forecasters had suggested. One of the important things to note with FDI, and I said this in my intro, is foreign direct investment flows go up and down a lot. They really fluctuate. Some years you get more than others for various reasons, whether there's been a merger and acquisition and large companies getting involved and so on. But I think in terms of new investments, things like Nissan, if the UK wants to continue to attract these kinds of businesses, and so far it seems to have been able to, as you point out, it may need to rely heavily on a state aid regime. So Nissan, the Nissan company in particular, received quite a significant package of assistance, if I'm not mistaken, from the UK government. Now, this suggests that maybe we wouldn't see these factories were it not for these interventions. And then the next step from that is the debate about to what extent are these state aid rules perhaps going to fall foul of the WTO subsidies agreement. And then, of course, with the Northern Ireland issue, which is still subject to EU state aid rules, and that's much more broadly reaching than people realize, because some of the subsidization in Northern Ireland or subsidization in Britain can have an impact on Northern Ireland, and that can engage the rules again. So it's, but I mean, these are in a sense larger geopolitical issues about the role that we see states having in things like the pandemic recovery around the world. And I have a feeling that most countries are going to be more sympathetic to state intervention. So I don't think we're going to see a lot of subsidies cases at the WTO, for example.
I'm sure that's right. Yes, Emily, Marcia has a question for you about linked also to this level playing field, saying that the commitments on climate change are subject to binding dispute settlement. And could you expand on this?
Sure. So I think the helpful sort of baseline here is the sort of shallow EU FTA. So EU, Korea, EU, Canada, something along those lines. And if we look at the trade and environment chapters there, they're based on a non-regression requirement, which is essentially that countries have to enforce their own domestic laws and not derogate in a way that benefits trade and investment. So what's different here is really two things. The first is that the non-regression requirements are a lot more focused. So, in a standard EU shallow FTA, it would be very broad, just any type of regression. Whereas here we have these quantitative, here are our requirements on your emissions reduction that are covered by non-regression, and this is specified. Same with effectiveness of carbon pricing. This is explicitly covered by this non-regression requirement. So there's the specificity, but there's also the fact that if you do regress, that mechanism can be enforced through sanctions. So in other words, if there's a dispute, one side says the other has regressed on their, interim target, the other can challenge that. It can go through the, the ladder process and eventually lead in to one side, suspending some of the concessions. So that gives it more sort of teeth. And then there's this whole rebalancing mechanism, which is this totally bizarre animal with all these new concepts that, material impact and some significant divergence. We don't really know what's going to happen with that. But I mean, basically, I think a way of looking at that is that, it was a very contentious area. I mean, it really, I don't know if any of you remember these kind of nail-biting moments when we weren't sure, if this was going to be no deal. And this was at the heart of it. This level playing field stuff was at the heart of that disagreement. So the way I see this rebalancing mechanism is it built this contentiousness into the agreement because it's a sort of fast-track dispute settlement mechanism. If you diverge, we can come down hard on you. So so it'll be really interesting to see how that kind of plays out.
Yeah, I mean, I think the one thing is certain is that the UK-EU economic and trade relationship is going to be a gold mine for lawyers and trade experts for years to come. It's the gift that's going to keep on giving. I've been asked to say a few words about the Northern Ireland Protocol by someone courageously, Peter van den Bosch. I'm not gonna take a long time on it because it's not really central to what we're talking about. But I mean, you all probably are familiar with the problem. Brexit means a border, basically. We know there's a border at Calais and at Dover. What do you do at the border on the island of Ireland? Because basically Northern Ireland, which is an integral part of the United Kingdom, becomes the border between Northern Ireland and the Republic of Ireland, becomes the land border between the EU and the UK. On the other hand, as part of the very complex and difficult peace negotiations in Northern Ireland, getting rid of that border or making it invisible was a very important part of the process. So Brexit posed an almost insoluble dilemma because on the one hand, it was all about building borders, and on the other hand, in a very sensitive part of the United Kingdom, the idea of rebuilding a border was going to be extremely difficult. There was a lot of discussion. In the end, what was decided is, in trade law terms, by the way, very unique. I mean, Northern Ireland, an integral part of the United Kingdom, remains to a large extent for trade in goods inside the EU, and at the same time is an integral part of the UK internal market. Now, as a trade negotiator, when I first saw that, I kind of said, okay, interesting to see how that works out. And therefore, the checks are put at the ports and the airports between GB, Great Britain, and Northern Ireland, because that's where the infrastructure already exists. Of course, this then politically puts a dilemma, particularly for the unionist community in Northern Ireland, whose whole sense of identity is linked to being an integral part of the UK, who feel that perhaps this diminishes that in some way, and that's where all the tensions have come. How you solve it, I mean, I think there probably are pragmatic solutions to many of the practical problems that have arisen. There was an issue about medicines, there was an issue about famously chilled meat and so forth. So there probably are practical ways of addressing these, but you need, unfortunately, a degree of trust, which is unfortunately absent for the moment, because from the EU's perspective, the feeling is that the UK is not really living up to what it signed up to. The UK feels, well, we signed up to something, but on the other hand, it's all in the implementation, and this is causing problems and causing political difficulties in Northern Ireland, and the EU should be more responsive to that. So that's where we're kind of caught in that loop. We wait to see. I think the UK has announced, I think Lord Frost said yesterday that he would come forward with ideas, with the formal British position on the whole future of the protocol in the next few weeks. So people wait to see what that will give. In the meantime, we're in a highly politically sensitive period in Northern Ireland. The 12th of July is a celebration of the victory of the unionist side, so to speak, and there's lots of marching and temptation for sort of community tension. So people are trying to desperately, I think, get through these next few weeks with a minimum of disturbance, and then try to get back to the table to figure out how we stick to the essence of the protocol, because I don't think there's any alternative, but finding flexible ways of implementing it that reduce some of the negative impacts which are there. But it's an impossible political circle that you're trying to square, because basically joint membership of the EU for the UK and Ireland was what hugely facilitated the peace process. And once you take that apart, you then pose, very, very many problems. So there you are. That's all I'll say about that. I see we have a question. Oh, we have a question from Vasyl to you, David, on the likelihood a bit like investment chapter in ISDS would be added to the EU-UK TCA later. Interesting idea. Given the difficulties the EU is having with investment chapters generally, I'm not sure they'll be in a hurry to try and negotiate one with the UK. But what do you think, David?
Will there be an enlarged investment chapter bolted on afterwards? That's an interesting question. I haven't heard that. I don't get that impression. I think my sense is that probably it would seem as though both sides are content to use domestic legal systems to resolve matters, and that those systems are robust enough that a classic BIT isn't necessary. The other thing to keep in mind is we're in an era where, and I know some of the other panels have looked at this issue yesterday, about sort of the declining relevance of bilateral investment treaties, and certainly the investor-state dispute settlement. Now, we know the EU has their own multilateral investment court concept that Canada has agreed to, and Singapore has agreed to as well, in slightly different ways. So I think if there was one, it would probably look like the investment court system. And my sense, just through various people I heard speak over the years, is that Britain would not fight it, would not put up resistance against the multilateral investment court if it was perceived that was a route towards gaining concessions in other areas. Then that's something that the UK would be happy to bring on board. But who's to say?
Okay, and Vasyl, Diana Wade has a question for you. Asking, do you foresee any disputes regarding rules of origin arising under the TCA? And if so, what dispute settlement mechanism would be the forum for that?
No, I haven't heard many disputes between members of a preferential trade agreement about the rules of origin, because, well, they normally have a shared interest in those. So it's unlikely, in my opinion. And yeah, I will stop here. It's very unlikely.
Okay. Johanna, I think you wanted to ask David a question.
Thank you. David, this is not a very defined question. I was just wondering, because we're talking, I think, correctly about this challenge of finding the reliable evidence and the material impact to really successfully invoke the rebalancing mechanism, and especially if we look at earlier examples from other trade agreements. And I'm just wondering, I don't know, I'm just thinking, do you think that the de facto alignment, as Emily put it, that we have between the UK and the European Union at the moment, would that play any difference? That we have this quite a special starting point where we have this regulatory alignment to quite a large extent between these parties, and would that somehow be able to affect the analysis of the evidence that when we diverge from this? And then it also came to my mind when David O'Sullivan was talking about the Northern Ireland and the Northern Irish Protocol, where we have these EU disciplines partly still applying to that part of the UK, subsidies, for example, so on, that could we somehow use the Northern Irish example in order to look at evidence, how would Northern Ireland differ from the UK, and how would that affect the FDI flows? So that's my question.
If the first, I think the first question was for me. That's a great question, Johanna. And in fact, I think it touches on the paper that I was writing, and my theoretical hook was this idea of punctuated equilibrium, which you may have heard. It comes from the biological sciences, but it's also been applied to political science. And the idea is that most political changes or most economic changes happen gradually, and then there's sudden, abrupt ones. And I felt that what we have with the level playing field obligations in the TCA seemed to me designed to deal with those really harsh breaks, those massive, abrupt divergences, and it's really designed to prevent those from happening. So that language of material and impact and evidence, and it seems to me this was meant to be used very, very exceptionally. This is only if something really radical has been proposed. Otherwise, the parties are essentially conceding that there's going to be gradual, sort of organic, maybe drifting apart, and we can live with that. I wonder this is very much, I like how Emily phrased it, is this idea that the contentiousness has been baked into the agreement, and I think that's true, but maybe in a good way, in as much as if it wasn't baked in, we wouldn't have had the agreement, and it seems to me that this may be actually quite a plausible, this was a sensible solution to the fact that there may ultimately be less divergence than what we might have thought.
I think the second question was also for you, David, which is, the impact of the elements of the EU state aid rules still applying in Northern Ireland, and the point that you also touched on, that how this can blow back and could create some impact on GB state aid activity.
Oh, okay, so when I heard Northern Ireland and David, I just assumed it was the other David. I'm so used to there being 5 Davids on every panel, but I don't hear my name. Yes, this is a problem, and it was only a handful of legal experts sort of noticed this, I think, in the months leading up with the withdrawal agreement towards the TCA, so the way it's phrased is that if there's state aid, if there's subsidization granted in Great Britain that has an effect on Northern Ireland, it will trigger it will be subject to EU state aid scrutiny, and this, in theory, gives the EU very significant power still over the UK's decisions and government's decisions in terms of what projects it's financing. And there was a number of really interesting examples that James Webber at Shearman & Sterling went through a number of really interesting examples. But this is quite significant, and some people suggested that maybe that provision should no longer be acknowledged because there's been a significant change of circumstances due with COVID. But I don't know that COVID would satisfy that very strict requirement under public international law that would allow Britain to essentially ignore that provision of the withdrawal agreement. So I think state aid, and recall, just to make one last point, the EU quite extraordinarily really expected the UK to fully align with its state aid rules, and that was its negotiating stance. And I think now that we've seen the Britain developing its own system, which my understanding is it has somewhat less transparency, less strict notification requirements, I think this is an area where there's going to be controversy going forward. But back to my previous comment, in an era where countries around the world are relying on their governments for bailouts and the pandemic recovery, maybe there'll be a somewhat laxer approach for some time.
Yeah, I think that last comment is very, very pertinent indeed. Look, we are almost reaching the end of our time because I've been told I have to stop, leave 10 minutes. We have 90, but we're supposed to leave a few minutes for the sort of changeover between panels. What I would just like to do is give each of you, the opportunity just to make a final comment. and I suppose the classic moderator's question to you might be to say, okay, in your chosen speciality, what's the one thing you think people should be kind of keeping an eye open on developments in that sector between the EU and the UK in the coming period? So, but if you want to just also add any other final remarks, please feel free to do so, and I'll take it in the order in which you began. So, Johanna, please.
Thank you, David. Well, in the area of services, I think there will be much to see, and I think the financial effects in the UK services sector are still very much developing. We've seen some early developments in the financial services area where there has been some relocation, maybe not so much as was foreseen, but I think there's still much to come. For the professional services in general, like I say, I think we have to wait a little bit for the travel restrictions to hit the service suppliers specifically. I believe it's often the smaller service suppliers that will struggle more. The big companies, the big four and the biggest law firms, they will do okay. They have the specialty and the expertise to navigate through these new complex rules, even though they will have to do some replanning of their operations in the EU as well. And they have already done a big part of that, I believe. In general, for services, I think it's really the time to start thinking a little bit more innovatively. And I'm so disappointed that the TCA was not did not take that occasion to really do some new thinking on services liberalization. I think we really have to separate the immigration part from the regulatory aspects of services, because here we have the typical protectionist issues relating to immigration, and then on the other hand, we have the concerns relating to consumer protection and the various regulatory preferences that countries have when they dealing with services. And we really, I think, have to put immigration aside and then focus on those regulatory issues. And I think we should really be able to use some kind of level playing field mechanism to try to understand how we could approach those regulatory barriers in order not to be too protectionist, but still keep the vertic protection goals in mind. And here, I think we have to somehow consider certain level playing field mechanisms in the future. I think that would be interesting. Thank you.
Thank you. Vasyl?
One of the developments that might happen in the area of rules of origin might actually be diagonal accumulation, or at least that's my big hope, that it can come in some form, either reference to the Pan-Euro-Mediterranean Convention or just simply a decision of the don't remember the name of the organ that was created by the institutional framework, that a diagonal accumulation would be applicable, at least with some preferential trade partners, or at least choose some products. That's all from me.
Okay. Emily?
So I think we've come to the point in the sort of the fight against climate change where we have to start thinking seriously about how we embed sort of carbon pricing discussions into trade relations. And it's a very, very tricky thing to do. It raises a lot of questions about multilateral implications. It raises a lot of questions about sort of governance and regulatory issues, international law, and it also drives innovation. So, you know, the stakes are quite high here in terms of whether, you know, can countries play together, and can they work together? Can they align their efforts? So, you know, I think what's come out from this is that the climate provisions are a sort of a relative area of optimism in terms of the UK-EU relationship, but also that there's a lot of potential contentiousness built into that. So to me, it's just a really interesting sort of test case of you know, can we, you know, push aside our differences and come together on this issue for the greater good, in a sense, or are we going to keep sort of sniping at each other? So I very much hope that it's the former.
David?
Yes, so I think a battleground for the future in terms of investment and EU-UK relations is going to be investment incentives. I think this is going to be a contentious issue globally. To what extent will companies be able to offer things like tax breaks in order to attract investment. And I think this plays into global discussions about the corporate minimum tax and how there might be carve-outs for certain sectors, such as finance, which we're seeing in the UK. And I think certain countries, and I think Ireland has resisted this because that's been something that's made Ireland very attractive to foreign investment. And I would suggest that we're seeing efforts at the OECD with the global tax rate. It looks like that's going to happen, the global minimum tax. I think the next thing we'll see with at the global level is some kind of a regime to control investment incentives, somewhat like the EU's state aid regime. There is no global regime to cover investment incentives, and I have a feeling that what we have under the TRIMS agreement and to extent under the subsidies agreement at the WTO are not sufficient, and I think we're going to see rules on that coming from the global community in the near future.
Okay, well, that's an interesting announcement. Yeah, my goodness. Well, watch that'll be quite a negotiation, and I'd love to see the US negotiating that with the state level incentives that they ambitiously compete with each other to deliver investment. Well, listen, I think we've reached the end of our time. I'd like to thank our four panelists very warmly for the work that went into preparing their presentations and their contributions today. Thank you to our participants. I hope you found it useful. And clearly this is going to be a subject that is going to be continuing discussion, and I can only agree with Emily. I mean, we know there is a lot of potential contention there, lots of things to disagree about, but I think many of us hope that at some point we can get on to a more adult relationship of trying to figure out how we make this new relationship work, respecting the fact that the UK has left, that the EU intends to continue and protect its single market, but that we should have the best neighborly relationship and mutually productive economically for us all. So I look forward to getting to that point. We're not quite there yet, I feel. Anyway, thank you all very much, and I bring our session to an end. Thank you.
Thank you.